Can you guys hear this? Let me know if you can hear me. Alright, she first, when I connected, it was playing stupid background music. The lady came in, asked who I was. I told her just somebody from the public that's been filing a case. She said, okay, so you're just a public citizen listening in? I said, yep. I said, I'll keep it muted. She then went away. She came back and said, are you the press? I said, no. She said, okay. She went away. Now we wait.
Good afternoon. Who just joined the call ending in 2735? Hello, someone just joined the call. I'm with phone number ending in 2735. Please identify yourself. Good afternoon. Who just joined the call ending in 5192?
This is Lita Walker from Ballard's Bar on behalf of Netflix.
Thank you. And Ms. Walker, do you anticipate anyone else appearing on behalf of Netflix?
Matt Kelly from my firm may also be on the line, as well as our local counsel, James Friedman.
Okay, thank you. I'll wait for them to dial in. Okay, one moment. Hello, who just dialed in with phone number ending in 7048?
Yes, this is Kevin Vick, counsel for defendants Pro Media, Laura Ricciardi, and Moira Demos.
Mr. Vick, do you anticipate anyone else joining us representing those three defendants?
I believe my clients may be calling in as well, just to facilitate the scheduling.
Okay. And who dialed in with phone number ending in 0371?
Good afternoon. This is Matthew Kelly for Netflix.
Thank you. Lita Walker's also on the phone with us. And who has phone number ending in 0476?
That is George Burnett.
Thank you.
Hi, this is April Barker.
Okay, thank you. Yep. Ms. Barker, I have George Burnett on the phone as well. Do either of you anticipate Michael Griesbach joining us today?
We do not.
Okay.
that might facilitate the scheduling.
Maybe, Judge, would you like to get started before they join us?
You can wait a minute.
Okay.
Go ahead, Linda, and call the case.
Okay. Counsel, I'm going to start recording the call, but first you're going to hear an automated lady say it's being recorded. Then I'm going to call the case, and you can officially make your appearances. So one moment.
This conference is being recorded. Only the main conference is recorded.
Good afternoon, parties. Magistrate Judge Duffin is present for case number 19CV484, Andre Colborn versus Netflix Inc. et al., called for a telephonic scheduling conference regarding mediation proceedings. I see someone has joined us who has joined us with phone number ending in 5924.
Laura Ricciardi and Moira Demos.
Okay, the two of you are together on the same line.
Correct.
Okay.
I'm
And someone just joined us with phone number ending in 3185.
Yeah, that's James Friedman from Godfrey and Kahn for all of the defendants.
Okay, thank you. Okay, so now may I have the appearances, please, for Andre Colborn,
George Burnett and April Barker.
for defendants Netflix Inc.,
Lito Walker and Matt Kelly.
and Mr. Friedman, you're on the line as well.
Yeah, for Netflix, yes.
Okay, for Chrome Media, Laura Ricciardi and Moira Demos.
Kevin Vick for all three parties, and also Mr. Friedman is local counsel for those three parties in addition to being local counsel for Netflix.
Okay, thank you. Okay, go ahead, Judge.
All right, good afternoon, everybody. This case has been referred to me by Judge Ludwig for purposes of mediation. Let me start by asking Mr. Friedman, am I to take the fact that you're representing all the defendants that at the mediation, it's expected that all the defendants will kind of be similarly situated in the sense that they'll all be in one virtual room at the same time, or separate?
Your Honor, that's a good question, and I would anticipate they probably, while they probably will be communicating some, they would want to be in separate virtual rooms for purposes of mediation.
But I'm assuming they do have different defenses.
I'm sorry, can you repeat that?
I'm assuming they have somewhat different defenses to the claim.
They do, Your Honor. In fact, you'll note there are separate, pending dispositive motions from the two different sets of defendants.
All right. Well, I know you guys asked for me, and no doubt the reason was my experience with handling the Brendan Dassey matter. I will tell you, I never did watch the Making a Murderer miniseries. Whether people believe that or not, when the case was assigned to me, I didn't want to watch it because I didn't want to be influenced by it in any way in the decision that I was going to make. And by by the time I finished the decision, quite honestly, I'd had enough of it, and I didn't want another dose of it by watching the series. And so I don't know if, and I gather from the complaint, and I just kind of quickly read the complaint in this case, that the plaintiffs think it would be helpful for the finder of fact to watch the series and to identify, things that the plaintiff believes are taken out of context or, cut and paste to leave the wrong impression. But I will tell you that I don't intend to watch 10 hours of the miniseries and then a bunch of transcripts of, alleged differences between what people testified to and what the series said. I think if that's what you want, you should probably go the private mediation route where somebody who's getting paid by the hour to do that would probably be more than happy to do all of that. But I'm planning on setting aside a full day for this, and I think we're going to need at least a full day for this because I think there's a lot involved in this. But I kind of wanted your initial reaction to my position that, I really don't want to get sucked into watching the whole Making a Murder miniseries, and I mean, typically I'll tell you what I typically ask everybody to send me for purposes of mediation. We'll get into that, but I even generally don't ask for people to send me summary judgment briefs and a lot of exhibits. That's really not what the expectation is when they have one of the magistrate judges do the mediation. So, let me start with you, Mr. Burnett. Do you think that it's important that the mediator have watched a significant portion of the series, if not the whole series?
No, I don't, Your Honor. I agree that it would be a poor use of your time and that the parties can provide you pertinent excerpts if they think that's appropriate.
Yeah, I mean, I get the flavor for what the allegations are, and I don't know that I need to actually see it in action by watching the series. I don't know that I need to get into it that much to be able to talk intelligently about what might be a possible, a good resolution of this. Does anybody else have a different view?
Your Honor, this is Lita Walker on behalf of Netflix. I want to make sure you understood that the defendants, just as much as plaintiffs, believe that it's important for the fact finder to review the challenge statements in context. But that said, we don't view you as a fact finder. This is a mediation, and my client is comfortable with you serving that role.
Okay. And Mr. Vick, do you agree?
I agree with my esteemed colleagues.
Okay. Well, we'll do this by Zoom. We're still not doing mediations in person because of the pandemic. And quite honestly, after nearly 11 months now of doing these by Zoom, I have found them to be really every bit as effective as doing it in person. There's really nothing that can be accomplished in person that we can't do by Zoom. And it makes it certainly much easier and more convenient for all of you because there's not travel involved. And so that's kind of the plan. And like I say, I plan on starting kind of first thing in the morning, and my first thing for these is 9 o'clock, although my real first thing is a lot earlier than that, so it's really whatever you guys are comfortable with is the starting time. And I will set aside a full day, and especially when we have multiple parties like this, and I need to meet with everybody kind of separately, it can take a while. And so I certainly will set aside a full day to make sure that I don't run into something else while we're, hopefully making progress. And I want you all to do the same. When we, in a moment, get to picking dates, let's make sure that we pick a date that everybody has got the full day set aside. because it's going to take all of that and perhaps more if we're making progress to get this thing to a conclusion. Have you guys had any settlement discussions to date?
None. This is Burnett.
Okay. Well, let's begin by. I mean, here's the process that we'll follow. I typically, once we pick a date, when we get together, we'll typically all meet virtually in one room, and I'll give the lawyers an opportunity to kind of, if they want, and I want you to talk about this ahead of time, make some type of an opening statement, brief, but some type of an opening statement to me if you want. Years ago, it seems like that used to be the norm in mediations. More recently, for whatever reason, it seems to be the exception. People typically, it seems like these days, don't really think there's much value in doing any type of an opening statement. So we typically jump right into kind of breaking you out into separate rooms and meeting with everybody separately. But talk about it with each other ahead of time. And if there's consensus, do you think a relatively brief, opening statement of your position for the benefit of the other side, as much as for my benefit, would be productive. If you think it'd be helpful for the other side to hear the other side's lawyer's perspective of the case, then we'll do it. And you don't have to tell me until that morning. But if anybody doesn't want to do it, if there's not a consensus, we won't do it. And we'll just jump into kind of a breakout session. So, and then I'll, typically, and I'm going to give you in a minute here what information I want prior to the mediation. And I will have read that and thought about it. And I will have a bunch of questions that I will invariably want, answers to give me a more complete understanding of the case and the parties' positions. And I'll get that information into my first session with each of the sides, each of the parties, and really stay away from, in that first session at least, with each of you talking about dollars. But then in subsequent sessions with each of you, get more directly into the weeds about, money and any other, avenues open to possibly resolving this. So that first session obviously is typically a decently long session with each of you as I gather information from everybody. So let's look at our calendars. And I don't know what time frame you guys were all thinking you would want to do this. If you want to do it in February, March, I have availability both months. I'm assuming nobody is thinking about going out further than that, but if you are, let me know.
Judge, this is George Burnett on behalf of the plaintiff. We'd be looking at something in late February or early March.
Okay?
That's fine with Chrome, Ms. Ricciardi and Ms. Demos.
Okay? Well, the first week of March, March 1, 2, and 3, at the moment, I actually have a court trial scheduled to take place by Zoom. So those days are out. Let's look at, the beginning of the next week, the week of March 8th. I could do 8 or 9. And if we had to, I could do the 10th. I have something at 9 o'clock, but I could reschedule if the 8th or the 9th did not work for everybody. So let's go start with the 9th. Tuesday, March 9th. Mr. Burnett, does that work for you and your client?
It does.
How about for Netflix? Does that work for your side?
Your Honor, it works for the lawyers, I believe. I need to check with Netflix, but I will do that even as we continue the discussion if I can reach them.
All right, how about you, Mr. Vick, for Chrome Media and the individual defendants? Does that day work?
That works for me. Moira, who I know are on the phone, does that work for you?
That works for both of us.
Okay, good. All right. So again, we'll start at 9 o'clock. I'm willing to start earlier, but not everybody's on Central Standard Time, so starting earlier, especially if there's anybody on the call from the West Coast. I know, Mr. Vick, I think you're in Los Angeles. Starting earlier, maybe even 9 o'clock is starting pretty dang earlier for you. In fact, is that too early for you? Do you want to start later than that?
No, 9 o'clock is okay, Your Honor. I have 3 children and a puppy at home, so I'm not sleeping in a whole lot these days anyway, and I don't want to hold up everyone else.
Okay. Well, let's start at 9 o'clock on Tuesday, March 9. We will send out a Zoom link sometime as that date gets closer. So working backwards from that date then, here's what I would like. So that there has been some exchange of information between the parties. What I would like to do by, let's say, roughly 3 weeks before, so let's say by Tuesday, February 16th, I'd like Mr. Burnett, on behalf of the plaintiff, to submit a written settlement demand to defense counsel with a brief explanation for why that settlement is appropriate. And then a week later, by the 23rd, I'd like counsel for the defendants to submit a written settlement offer to the plaintiff's counsel, again, with a brief explanation for why that settlement is appropriate. And the expectation is that those will be compromised positions of the parties and not setting outer boundaries of everybody's, best case scenario. In fact, I'm going to, in a minute here, I'll tell you, has plaintiff's counsel send those to me, and when I get those, if they are, I conclude that we are hopelessly far apart, I reserve the right to cancel the mediation. So be mindful of that when you put those numbers down on paper. And I know that they're not going to represent everybody's final number, and I don't expect that. I understand how this process works. But they are intended to represent a compromise already on the part of everybody, so that when we get together, we have some numbers that we are beginning to work with that are reasonable numbers. But I don't want to waste your time, I don't want to waste my time, I don't want to waste your client's time getting together on March 9th if it's just going to be a waste of time. So then, moving closer to the mediation then, let's say by the week before, that would be March 2nd, by close of business at 5 p.m., I'd like everybody to send me the following, starting with the plaintiff, Mr. Burnett. First thing you're going to send me is you're going to send me a copy of those letters that I just had you all exchange. Then everybody is going to send me 2 letters. One that you carbon copy all other counsel on, not exceeding 5 pages in length, single-spaced. And all this information, by the way, is going to be included in an order that we will issue, so you don't need to worry about the details. That tells me, your position on the fact issues of law, and damages. Obviously, I'm going to be familiar with the case, but just tells me a little bit more about your perspective of the case. And then I want you to send me a separate letter that you don't carbon copy any other counsel on. It tells me anything else that you think would be helpful for me to know prior to the day we get together for the mediation. It could be, an important fact that you think the other side isn't aware of, or maybe they're aware of it, but they're not giving it due weight from your perspective. It could be, an issue you're having with opposing counsel. It could be a problem you're having with your client. Just anything else that is a hurdle impediment to settlement that would be helpful for me to know before we all get together on the 9th, so I can think about it and consider how to possibly clear that hurdle. And I'm not looking in that for anybody to give me their bottom line number. I'm just wanting any other piece of information that you think would be helpful for me to know, that for whatever reason, personal to you, you just don't want to put in the letter that you copy opposing counsel on. And then we'll talk about it. The stuff that you put in that letter when we get together, and maybe I'll view it as significant enough as an impediment to settlement that I'll, talk to you about whether some of it should be shared with the opposing counsel, but obviously I won't share anything that you don't want me to share with anybody. And that's all I need. And despite me telling people I want 2 letters, sometimes I get one. Not sure why, because I say it in the call and then I put it in the order, and sometimes I'll still get 1 letter from somebody. I'm not worried about that with this crowd. I'm confident you guys will be able to follow those pretty simple instructions. And like I say, I'll read that, whatever you submit, and I will, as part of my preparation, draw up a list of questions that I have based on what you've submitted, and be prepared to ask you questions when we get together in our separate breakout sessions to get some additional information. And I do expect that everybody will have a representative from their client present that has full settlement authority without having to place a phone call to somebody else. And especially now that we're doing these by Zoom, makes it really easy for somebody to come in because they don't have to travel to Milwaukee for the mediation. It makes it easy for that person to jump on the Zoom call and participate without necessarily being on the phone the whole time. So any questions about the process?
No, Your Honor.
I think we're clear.
No
Okay.
questions, Your Honor.
Okay, well, like I said, we'll go as long as we're making progress on the 9th, and I will stick with it as long as it takes. But if it becomes apparent at some point that it's just not going to happen, then I'll let you know that, and we'll kind of call it a day. But I'm hoping we can get this resolved for you and for your clients' best interest, because obviously litigation is expensive, it's time-consuming, it's distracting, and I'm sure everybody would prefer to have this kind of behind them. All right. Well, like I say, we'll issue an order with all this information in it and some additional stuff that you're just going to want to know, and then we will see you all on a Zoom call on March 9th.
Thank you, Judge.
Thank you, Your Honor.
Your Honor.
Thank you.
Thank you all.
Thank you.
Yep. Bye.
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 We're sorry. Your conference is ending now. Please.
So, March 9th. Unless they come to an agreement before that. What are your thoughts? This almost didn't happen. I initially called the clerk's office and I asked for the connection number after you dial the phone number. And she was like, "Why are you calling?" I was like, "I'm just interested in the case. I've been following it." She was like, "So you're just from the public?" She was like, "I don't think you can do that." I was like, "It says right on the website that you can." Like, her interest peaked more once she read which case it was for. Then she started asking me all kinds of questions. Finally convinced her to give me the number. Then I called. I get connected. The lady asked me why I'm calling, if I'm part of the case. I said, "No, I'm just calling from the public. Just curious, been following the case, just want to listen in." She says, okay. Comes back a little bit later and was like, are you from the press? And I'm like, no, not from the press. And then I got connected. But the next one's going to be a video call, so I will be making a call to the clerk's office to see how I get access to that. So, stay tuned.